Welcome to EU Privacy for All, Session 48 on GDPR, Cooperation between Supervisory Authorities, One-Stop Shop, Article 54a. Article 54a was proposed by European Parliament. In the context of the activities of an establishment of a controller or a processor in the Union, and wherever the controller or processor would be established in the Union, or where personal data of the residents of several member states would be processed, the supervisory authority of the main establishment of this controller or processor would act as the lead authority. That is to say, lead the reflection and the data protection decision all across EU. This is a one-stop shop principle. Taking appropriate measures would make it possible to reach a consensus and a consistent approach EU-wide. The EDPB, European Data Protection Board, would help identifying the lead DPA wherever it's unclear or DPAs would not agree, or when the controller is not established in the Union. Most of those proposals were retained in the final draft of GDPR. The final draft of Article 54a, in paragraph 1, sets the principle of the one-stop shop. That is to say that the lead supervisory authority shall cooperate with the other concerned supervisory authorities in an endeavour to reach consensus. All DPAs shall exchange all relevant information. The lead may request at any time any other DPA to provide mutual assistance or conduct joint operations, in particular carrying out investigations or monitoring the implementation of a specific measure. The lead, once again, shall communicate the relevant information on the matter to the other concerned supervisory authorities without delay, and without delay once again submit a draft decision for their opinion to be taken into account. Where any of the other concerned supervisory authorities would, in a time frame of 4 weeks, express a relevant and reasoned objection to the draft decision adopted and proposed by the lead DPA, this lead DPA would have, if it does not follow the objection or is of the opinion it is not relevant and reasoned, to submit the matter to the consistency mechanism. Where the lead DPA intends to follow the objection made, it shall submit a revised draft decision that will be validated within EDPB in a time frame of 2 weeks. Where none of the other concerned supervisory authorities has objection, the lead supervisory authority and the concerned supervisory authorities shall be deemed to be in agreement. The lead shall adopt and notify the decision to the main establishment or the single establishment of the controller or processor. However, the supervisory authority to which a complaint would have been lodged is the one in charge to inform the complainant on the decision taken by the lead. By derogation, where a complaint is dismissed or rejected, the supervisory authority to which the complaint was lodged shall adopt the decision and notify it to the complainant. Finally, where the lead and the concerned supervisory authorities are in agreement to dismiss or reject parts only of the complaint and to act on other parts of that same complaint, a separate decision shall be adopted for each of those parts of the matter. The lead shall adopt the decision for the part concerning actions that will be followed up by enforcement potentially, while the supervisory authority of the complainant shall adopt the decision for the part concerning dismissal. Finally, the controller or processor shall take the necessary measures to ensure compliance with the decision and shall notify the measures taken for complying with the decision to the lead supervisory authority. Urgency procedure could be implemented in certain cases, and the lead and other concerned supervisory authorities could interact and exchange using electronic means and a standardized format. Key recitals in GDPR are recitals 97A, B, C and 98. Basically, each supervisory authority not acting as lead should be competent to deal with local cases. This is the key input of recital 97C. After being informed, the lead supervisory authority in such a local case should decide whether it will deal with the case or not. In such a decision, it could be led to the supervisory authority, which informed that it will deal entirely with the case. Recital 97A and B reminds us on the key principle already laid down in Article 54a. A key additional input comes from Recital 98, stressing that the rules on the lead supervisory authority and the one-stop-shop mechanism should not apply where the processing is carried out by public authorities or private bodies in the public interest. In such cases, the only supervisory authority that will be deemed as competent is the one of the member state. Article 51a on the competence of the lead supervisory authority reminds that the supervisory authority of the main establishment will act as lead in case of cross-border processing. Article 58a(1)a on dispute resolution by EDPB also makes clear that EDPB shall adopt a binding decision where a reasoned objection and a relevant one has been stressed by a supervisory authority, or when the lead has rejected an objection as being not relevant and or not reasoned. Currently, the directive lists in Article 28 that each supervisory authority would be competent but shall also cooperate with one another. Not more on the one-stop-shop mechanism that are a brand new provision in GDPR. What should accountable data controllers and processors get prepared for? Controllers and processors should identify their lead supervisory authority and all concerned DPAs on a case-by-case basis. The lead supervisory authority may request at any time other concerned supervisory authorities to provide mutual assistance, notably, and this is to be in mind as a controller or processor, for joint operations such as investigations or the specific monitoring of a measure. They shall also bear in mind that the lead DPA will be the one drafting the decision. There is, thou, an exception, that is to say, in cases concerning public bodies. Each concerned DPA might trigger relevant and reasoned objection within 4 weeks to the draft decision that is initially proposed by the lead DPA. In case of disagreement, the consistency mechanism that will be described afterwards will be put in place. The lead supervisory authority will be the one notifying the decision taken to the main establishment or the single establishment of the controller or processor. However, let's stress that the DPA to which a complaint has been lodged will be the one in charge to inform the complainant on the decision. A complaint can be partly rejected and partly validated. In such a case, the part that would be rejected would be monitored by the concerned DPA, informing the complainant. The part that will be validated will be monitored by the lead that will inform the main establishment on this part. Controllers or processors will have to notify the measures taken for complying with the decision to the lead supervisory authority. And finally, each non-lead DPA will deal with local cases to be defined. So the key question that we might have in mind now is knowing about the consistent implementation of such a new process, that is to say the one-stop shop, and the way the lead and concerned DPAs will interact.